Welcome to Whatsoever More or Less. My name is Jason, and today I want to talk about the idea of judicial review and the tradition of the founders, and how judicial review didn't even meet the threshold required to get onto the Constitution at the Framing Convention in Philadelphia, let alone the final product. So, first off, let's talk about that every state had constitutions. As far as I understand it, there might have been a state or two that didn't yet, but I'm pretty sure they all did around 76 or so. And what they did with their constitutions, this is the typical pattern that you'll see that we also find in the federal constitution, is they lay out the purposes for which government is valid. They lay out the positions of power, the manner in which the people's consent is given for people to enter into that position of power, the procedures to exercise their powers with thresholds required of votes in order for an act to be considered binding, and then the enumeration of the powers relevant to each of those positions of powers. There are promises guaranteed. These aren't optional powers. They are the ones that have to be carried out. And then there are powers prohibited. And this is fairly standard way of doing things. So if it's not on the list, it's not on the list. If it's on the list, it's on the list, right? And that's the enumeration of powers, for example, right? If a procedure is in there and it's written down as a binding procedure, it's there. If a procedure isn't there and isn't written down as a binding procedure, it's not a binding procedure, right? If a position of power isn't there and yet it makes itself up and creates this new position of power, it doesn't matter. It's still not there. It's not actually valid for the Constitution, right? There typically tends to be also a manner for amending the Constitution. So just in case you feel you need to add some of these kind of things to it. But what happened at the framing convention, right? You had 74 delegates invited. Out of those 74, I believe 54 or 55 were regularly in attendance or fairly regularly in attendance. Alexander Hamilton had the most extreme plan, if I'm not mistaken. Governor Morris was right up there with him. Alexander Hamilton was told, yeah, we're not even kind of interested in your plan. And Governor Morris, he got he proposed a lot of stuff. And all that stuff that he proposed, not a whole lot of it went through, but a decent amount did. So he ended up being part of the Committee of Style. Madison did too. Hamilton did too, if I'm not mistaken. So, but anyhow, all these different proposals were made, and then they needed to be organized. And out of all those proposals, it was discussed the idea that the judges would strike down something that was unconstitutional, or they wouldn't enforce it. There was about 25 different delegates to the Constitutional Convention that argued for something like that, but it never made it into the official list of procedures that were laid out in the Constitution. It did not make it into Article 6, Clause 2 of the Supremacy Clause. It didn't make it into Article 3, Clause 2, the list of enumerated powers. And if you think that the Article 3, Clause 2 isn't a list of enumerated powers, James Madison, during the ratifying convention, which I would consider more serious, probably, even though Alexander Hamilton wrote the Federalist Papers, those were just newspaper articles, versus James Madison in the minutes of the debates at Virginia for ratifying the convention. I think I'm saying this right. Patrick Henry complained. He's like, they're going to look at this first phrase before the first semicolon and claim power over all cases. And Madison's like, no way, dude. This is written out with enumeration of specific types of cases. It's an exhaustive list. That's what it is. It is the total list of everything that they're allowed to exercise power over. And that's it. So you have to read through everything after that first semicolon in Article 3, Section 2, Clause 1. Okay? And that's what Madison said. Madison said that's the exhaustive list of all the powers they would have. So they do not have the power of judicial review, according to Madison, right from the start. They have the power to, according to their oath of office, which everybody has, and Madison kept saying this throughout his life, that everybody has a concurrent equal power. The president has his oath. The Supreme Court, all the judicial branch has their oath. The legislature has their oath, or Congress, as you want to call it. And all of them have the exact same implied responsibility then to know the Constitution and to stop unconstitutional acts. Right? It's not a single responsibility on the Supreme Court only. That was argued for maybe by a couple people, Hamilton in particular and Morris. But again, we just clarified they're the most extreme. And the only way it was argued for after the convention to the people was in some newspaper articles to the state of New York. When Thomas Jefferson heard about this years later, he said, oh man, that would make the Constitution a complete suicide pact or something like that. It would make the judicial branch an oligarchy, a tyrannical branch, right? So it was rejected. It was rejected by Madison. It was rejected by Jefferson. It was rejected clearly in the debates before they agreed to ratify the Constitution. Then, this is the other thing we have to consider. The only way it got ratified is with the agreement to make amendments, which Madison took very seriously. And I respect Madison because he wanted more of a national government. But he was willing to keep the agreement that they came to. And so that first year in session, that first session, he made, proposed, I think 12 amendments were proposed. 10 of them got ratified. I think I'm saying that right. And that's where we get our Bill of Rights. The final one, the 10th Amendment says, the power is not prohibited to the states or reserved to the federal government, are reserved to the states or the people respectively, one or the other, right? So the judicial branch has powers is what it's called. If you read Article 3, they're referred to as powers. So whatever the judicial branch has, they're powers. And if they have powers and they haven't been reserved to the federal government, nor prohibited to the states, they're reserved to the states. So far, I'm seeing that it's not in Article 6, Clause 2. There are only 3 things that are in Article 6, Clause 2 that are binding on the judges in all the states, that are binding on the officers in all the states and the federal government. 3 things. 3 things. The Constitution itself, the laws, and the treaties. That does not include Supreme Court opinions. Okay, there's a very clear threshold for something to become part of the Constitution. There's a very clear threshold for something to become a law. There's a very clear threshold for something to become a treaty. There's very limited understanding of what a treaty was. It was for ending wars. It was for claiming lands, and something else about. Anyhow, the treaties had a very limited application back then. Okay, so they didn't even enumerate the treaty powers because they were just hardly anything back then, and we have to follow the definition that treaties had back then. Unless somebody wants to amend the Constitution to augment what the treaty power is according to modern standards, it still retains the meaning it had at the time it gained legal force. Okay, and so some people would like to say, and I want to go ahead and call out the Utah Valley University, and oh gosh, this other Constitution guy I listen to, and I listen to these guys. Trust me, I listen to them all the time, and I've decided to get over my irritation at their dishonesty and just listen to them. Because they always say something I can learn. And then to top it off, also I learn the dishonest tactics that people use. Utah Valley University in particular, their Constitution Center or whatever they call it, has one of the most dishonest approaches where they say, look, when judicial review happens, it's not like the law is taken off the ledgers of the U.S. Code, right? Or when the judicial branch, when the Supreme Court makes a ruling, it's not like it actually amends the Constitution. It's besides the point. As a matter of fact, that we call it a difference without a distinction. It's one of the most dishonest tactics in the world for saying what something is, right? The fact is, for all intents and purposes, that's what happens. The final effect is the same as though that had happened. And to top it off, what's even worse, it would have been better to just amend the Constitution, because at least then the people could look it up and say, I want to study the Constitution. Wait a second, why are we doing this in this country when the Constitution clearly says it's not allowed? Or when the Constitution clearly doesn't give the power to be doing this? Oh, such and such Supreme Court decision. Supreme Court decisions, that's actually worse that the Constitution doesn't include those decisions, right? Because now it's not accessible to we the people in the first place, right? So this is, why would we keep doing this? I made a video the other day, which I kept it to myself because I'm too nice if I got to do it. Everyone is complicit. The Congress likes it when the Supreme Court comes up with an explanation for why something is constitutional and doesn't strike it down when they should have struck it down. President, same thing, likes it when the Supreme Court says something the executive branch is doing is constitutional because some expanded explanation and twisted explanation of what the Constitution says. They all like it. So then they occasionally get struck down, but more often than not, it's 2 steps forward to take a step back, 2 steps forward to take a step back. And that's why we have so much more powers than just the 18 enumerated powers to Congress, or what is it? I think it's like 10 different types of cases, 8 or 9 different types of cases that are enumerated to the judicial branch, the executive branch. This is insane. It's out of control. And that's not President Trump's fault, by the way. He's actually been trying to undo a lot of that, which, You know, I'm not a massive fan of President Trump, but I think he's been doing a lot of good things at the same time, too. So I'm just a strict constitutionalist. Religiously, I believe in whatsoever more or less comes of evil. Okay? If it's more than what the Constitution allows or less than what the Constitution calls for, it comes of evil. That's my religion, my testimony. The Savior called me to believe in that. I believe in it, period. Why question it? He said it. It's got to be true. That's all there is to it. So we got to do it right. President Oaks has complimented amendments while saying we don't find inspiration in judicial review. Okay? And he's called our Constitution inspired. And he's refused to call. I've never once heard him say, oh, that's an inspired Supreme Court ruling. Never once. It's because it's impossible. It's more than the Constitution allows for. So, thanks for listening, you guys.